Hey folks, this is Tim with Jefferson County General Assembly.org from Jefferson County, Pennsylvania. And just want to go on the record as saying that pretty much everything that um, I share online, I share it. Of course, I'm not an attorney, um, but according to you know uh, Article 5, which most people say, oh, we have the right to remain silent. Well, Article 5 is pretty big. It actually has a lot of good stuff in it. We have the right to counsel, right? And counsel is not an attorney. That's not a counselor. An attorney is an attorney. And if an attorney wants to work as counsel, that's good. If you want an attorney to work as your counsel, that's up to you. But counsel does not have to be an attorney. So I counsel people. Um, but everything I do is on the private side. Um, and that being said, of course, there's a difference between what's legal and what's lawful. What's legal is what goes on in a corporation. What's lawful is what is deemed right by either the Constitution or by the King James Bible. In my case, you can use the Geneva Bible or anything, but do not use the New International Version or the Living Bible. Those are crap. And I've mentioned that on other videos. Nevertheless, I want to talk quickly about common law, and I have an article that I'd like to read through. Common law in and of itself is very broad. It's very broad because I had used this, let me see, on another video where it says God is on top. God created man in his own image. Right here is common law. God's law, the law of nature, man's law is the common law. So common law, common sense. So the laws of nature, cats and dogs have a law built in among themselves. Dogs chase cats, and if the cat turns around and scratches the dog's nose, then everything's legal. That's common law in nature. All right. So there is, for example, there is English common law, there's British common law, there's, every tribe that has ever existed has had their own law. That would be common law to them, whoever they might be. So the Mayans, the Aztecs, every Indian tribe, that you can think of, the Cherokee or Iroquois or Navajo or Shoshone or whoever that might be that you're thinking about, they all have their own law. And that's common law. That's common to the people. That's what common law is. I talk about American common law because American common law is what is common to American people or people here in the United States. So I'm going to go ahead and read through this real quick. And it's just talking about common law. It's something that Anna von Reitz had written a little while back. And she starts out talking about people in the Stone Age, of course, and every tribe having their own common law, and the British coming up with their own common law. And then, of course, she mentions, the common law of the United Kingdom is not the same as any other common law. And what happened was, we came together, and we here in the United States, all the way back, 1500s, 1600s, whenever we came over to the United States, 1492, Columbus sailed the ocean blue, right? From that point forward, European common law was introduced to the Turtle Island, which is the United States overall. They called it Turtle Island. So common law can exist in any jurisdiction. You can have civil law, which they call common law. You can have, but it's a corporate common law. You can have uh, a federal common law, but that's actually called martial law or martial common law. Um, and so what happened was, I'm going to read down through this. Um, you can have commercial common law, state common law, county common law, military common law. You have ecclesiastical law, which is the common law of the universal church or whatever church you might be with. And then there's canon law, which is more specific, and it's more specific in a codification of ecclesiastical law. And so moving on, there was a point in time, Anna writes, when Lord Mansfield of Great Britain became Lord Chief Justice in Britain in 1756. And he brought along both his experience in Admiralty law and as a Scotsman, which would have been common law. And at the time, English common law required an actual wet ink, two-party, fully disclosed, equitable agreement based on a meeting of the minds expressed in writing by freely consenting parties, and that was deemed old-fashioned by him. Now, what I just explained is our American common law. Okay, so we can make a contract, we both have to sign it. It's an equity agreement of one sort or another. We both agree, and we do that in writing. That's common law. That's American common law. All right. But what this fella did, Mansfield, he didn't think this was convenient. So what he did was he advocated an honor system, which is the same stupid system that British equity law is using right now. And it sucks. All right. So instead, he advocated a system of honor by which full disclosure and consent to the contract should and could be merely implied by acceptance of some service or benefit, and which also favored giving judges discretion to act in equity, allowing them to escape the narrow confines of a written law. So this is what they do. Remember, I've talked about the birth certificate a lot of times. So whenever you sign up for a benefit from the corporation, then they believe that you have applied to the corporation because you accept a benefit. All right? So this is an advocated honor system. So the judges believe whenever you say, I want to be a voter in the corporation, I am a registered voter, that you are a part of the corporation, full in 100% part of the corporation. So that gives them jurisdiction over you in everything else that you do because you must honor that contract. So what happens under this law, so continuing, Lord Mansfield merged the common law into the Admiralty system, and this is what UCC does at international law. But they use civil law, and they try to mix this stuff together. So it's a dreadful mismatch that could be interpreted endlessly by the courts, and they do that are supposed to be administering justice in behalf of the people, but instead the people become victims of what then posed as their own justice system. It is from this meager merger of laws and forms that we get such horrors as unilateral contracts in which only one party has to sign, which is a total bunch of crap. That's how they actually sell houses and stuff nowadays. I mean, that's how they sell cars and automobile, right? That's why you can get out of an automobile contract because the other people never signed it. At common law, you have to have two signatures. So these people are going into courts, and this savings and loan company is trying to steal their house, but there was never a contract to begin with at common law because there was never two signatures. There was only one. One person signed, the person who was buying, but the seller has to sign that paper. So think about it. So they create victimless crimes, and they make up arbitrary prison sentences, and they abuse the judicial discretion, for which then the judges take their personal buddies. This is something I talked about on one of the other videos, where these people down in Alabama were having their automobiles stolen. This guy that I was watching a video on, they stole his van, and then they stole his truck, one year after another, because they didn't like the guy, and they gave them away to someone else in the same town, and that other person's driving it around, and this guy can't figure out how to get his van back and how to get his truck back. So he's figured it out. He's figuring it out. All right. Nevertheless, the Americans rightly, objectively, strongly objected to the merger of English common law and admiralty law and all the abuses that would logically come from it. So that's what I was telling you to begin with. Our American common law is not subject to equity. Equity courts are a total fiasco. They can just choose to do whatever they want, whenever they want, however they want, especially in places like Australia or Great Britain or somewhere like that. They just really don't care about the people at all. So the upshot of the English common law was hopelessly polluted, twisted, and by the bar associations, and they screwed everything up, and it was everything at their own discretion. So American common law retained its separation from admiralty law and maintained its prohibitions against the implied and unilateral contracts and the judicial discretion and equity decisions. So all of this, though, all of this stuff I'm talking about can be called common law, because, like I said, there could be martial law could be common law, because every group has its own thoughts about what is common to it. So you have to be very specific. In the United States, you don't want to say, I'm here under English common law. No, no, no. You want to make sure you say, I am at American common law. Because English common law is very different from American. All right? And Polish common law is very different from English. And German common law is very different from the English. You know? So Russian common law is not the same as the United States. Understand what's going on. Common law is common to them people, whoever those people are. So that's why we have to state American common law on our paperwork. American common law when you go into court. Okay, so I hope that this helped to clear up common law a little bit. Remember, at common law, if you don't harm or you don't injure anything, then nothing happened. All right, so have a great day, and we'll see you next time around.